I want to talk about commercial disputes, but I want to make a contrast. I want to contrast between commercial disputes that are business-to-business commercial disputes and commercial disputes that are business vis-a-vis consumers, business-consumer disputes. There are some important differences to take on board. In business-to-business disputes, the focus usually is on the contract that exists in some sort of business-to-business relationship, whether it be it could be business-to-business in the sense of a joint venture. It could be internal business dispute, in which case you may be talking about shareholders in a business together. You may be talking about a partnership. Those sort of commercial disputes don't involve consumers. They involve the people who have come into a business relationship with each other, either within the single business and they fall into dispute. So that could be a partnership, it could be a joint venture, it could be shareholders in a company. Then there are commercial disputes that come into existence between a business and its consumers. The way to approach these different sort of disputes is going to be affected by which kind of dispute they are. And that's what I want to talk about here. So the big important difference is this. When you're talking about people in business have an internal dispute, or you have people in one business that are in dispute with another business, maybe they're doing business together or they're not, maybe they're competitors. In looking at how to manage that dispute and how to get people to resolve it early, a primary factor, as I've spoken about elsewhere, is identifying respective commercial interests and where those commercial interests might come together so that part and parcel of managing, resolving that dispute is focusing on how to address those commercial interests, how to take a situation where it looks like commercial interests are opposed, but actually to find where they have common ground and where you can look for options in resolving that dispute that help foster those commercial interests. That becomes a very, very important point, focus point in managing that dispute. It's different with consumers. When you have consumers, they're members of the public, and in many, many cases, when consumers are in dispute with your business, they may have purchased something from you. There may be a consumer contract, but in most cases, businesses will simply have a standard agreement, and that standard agreement has to be accepted by the consumer. Now, that's the case, for instance, when consumers are purchasing online. It may be the case when they're doing a special order. You have standard terms. They have to sign off and accept those terms, and then you provide the service or you provide the product. But in other instances where they walk into your shop, they just simply purchase something. Now, maybe what they purchased isn't what they thought it was going to be, or maybe it's defective in some way. That could lead to a consumer dispute. In other instances, the consumer might say that you represented certain things to the consumer, and they relied on that, and that's why they bought it, and they don't care what else you've put in your contract trying to protect yourself and how you've sought to qualify your responsibilities, where you made certain representations to them. The important point here is that consumers have other laws that come to their aid, and that's called consumer law. They have consumer rights, and this comes from a whole variety of legislation. Under one broad banner, we'll just call it consumer laws or consumer protection laws. So it's absolutely vital that every business, if you want to minimize your chances of getting into dispute, that you get appropriate advice about those consumer laws to make sure that you're adhering to them. There's one thing all businesses must understand is that contracts alone when it comes to consumers may not be enough to protect you, because no business can contract out of consumer laws. Now, just as I've said elsewhere, that when businesses are in dispute with other businesses, one needs to take into account commercial interests and as well as strict legal rights. Strict legal rights that flow from a contract or from some piece of legislation like trademarks, copyright, etc. And businesses can work out their own agreements to resolve that dispute based on their own perception of commercial interests. But what about consumers? Again, there's room to move. When a consumer gets upset, you always have a choice in deciding how you want to respond to that. And if you come to someone who, and you say, look, I don't really want to go to court over this, I want to get you to help me resolve this commercial consumer dispute without litigation, without going to court, well, what are the sort of things that we can talk to you about in terms of exploring options? Well, there's quite a few. Because again, in looking at your broader commercial interests, you may be dealing with a consumer that will give you much repeat business well into the future. That's something you may want to take into account, deciding how you want to deal with that dispute. It may be a dispute that, if you don't handle it properly, will give you a lot of bad flack in the press. It may be potentially damaging to your reputation, your commercial reputation. Consumer simply wants to be a satisfied consumer, and they've raised a dispute with you because they're not satisfied. So when you look at it from that respect, you might, at first instance, look at it and say, well, strictly, I'm not at fault here because certain things are stated in my contract, and I'm just going to rely on that. But you might say, well, strictly speaking, I've got rights here, but I can understand why the consumer's upset. And I've got a policy here which I'm going to apply, which is, I want my consumers and my customers to be happy. Now, if we're dealing with a dispute here that's not worth hundreds of thousands of dollars, and this is, put it in proper context, this is where companies and businesses always have a choice. These are often governed by, not strictly by your contract with the consumer or your perception of your contractual rights, but your internal policies dealing with disputes. That gives you a lot of latitude. Now, I know, and just to give you an example, one example out of many, because one area that I'm very, very familiar with is building disputes. Residential building disputes, they can get very hot, right? Now, I'm just going to give you one contrast here, but this can be applied in many, many different ways. When you have a husband and wife who's just made a contract for a lot of money to have their dream house built, they are very, very sensitive about the builder doing the job well. And they want to know that their money is being well spent. And if they're a happy customer, they may recommend this builder to many others. And so a lot of additional business can come the way of the builder who manages their client properly. But here's an absolute stark difference between the way that different builders who have contracts with these homeowners will deal with a dispute. One I will call falls smack bang in what I call the confrontational, litigious mindset and approach, and the other one I'll call the cooperative, creative approach, which is looking at everything to do to avoid litigation. The choice is always there. Now, there are some builders out there who run their businesses in a way that they say, I am always right, and the owner is always wrong. And if the owner doesn't like the way I'm doing things, we'll go into court or we'll go into the tribunal. I am never going to back down. That is an approach that is destined for conflict and litigation. Now, when those cases run through the court, of course, there's going to be some builders who are found to be right and some who are found to be wrong. But they have to go through sometimes a very long and expensive process to be vindicated. If they're wrong, they pay a very big penalty. They may have to pay a lot of legal costs of the other party. They may have suffered a lot of cash flow damage to their own business because they're distracted by the litigation. And they may suffer a lot of bad press for their reputation, which may kill off other business. Now, here's the contrast. I know for a fact that there are quite a few big builders out there now, which they're called volume builders. They do hundreds of houses every year, and they have massive budgets. Well, their attitude is they will bend over backwards to meet the concerns of their consumer, of their client, of their customers, even if, in some instances, they believe they are totally in the right and the customer client is in the wrong. They do that because they know that it works to their benefit commercially in the long term. Now, they're not silly, and they don't throw money down the drain. They just have better policies and procedures to deal with disputes to help them be managed efficiently and well and resolved quickly, because they know that the sooner this dispute is off the table and resolved, it's better for them commercially. There's ways to do that. When they see a dispute happening, they don't come and lock horns straight away with the owner because they know that will only escalate the dispute. They try an alternative. Well, one of those alternatives is to say to the owner, well, look, you could be right. We don't think you are, but let's bring in a neutral person here. Let's agree on who it will be and have him or her look at this situation and give a report that we can both look at. Now, if that person is satisfactory to you based on his or her reputation in this trade, let's not fight over this. Let's get down to the site as quickly as possible. You can bring your expert if you want, and we can go down there and we'll bring this neutral person in and we'll go through your issues. And we'll stand right back and we'll listen to what this neutral expert tells us. And if that neutral expert tells us we've done certain things wrong, we'll fix it up straight away. Do you see? That's a totally different approach to the first builder I mentioned. And it pays huge dividends over a period of time to the builder. So that is a consumer dispute. The owners are the consumer, and the builder is the supplier to the consumer. At the end of the day, they are resolving these disputes on a what we call in a commercial way, in a commercially sensible way, rather than just insisting on strict legal rights. And that's the main distinction I want to get across in this particular talk, that whether it be a commercial dispute between businesses or an internal business dispute or a commercial dispute with a member of the public, a consumer, a business always has the choice to do this balancing up exercise of strict contractual rights or legal rights as against what is their bigger commercial context. Just before I finish off, I just let you know that I've done another blog post that you can find on this site, specifically on explaining the difference between rights-based disputes and interest-based disputes. And if you're interested in to know more about that difference, you can, there's a link to that other blog post immediately below this video.